Hi, thanks for coming and thanks for having us. It's a pleasure to. I can't wait to listen to everybody here, and I won't say much. I will just try and learn as much as I can. I want to introduce, first of all, speakers today. So we have the small bios. Bear with me, I'm going to read. So first is Jenny Xiang. Correct. So Jane is a professor of law who teaches and writes in the areas of international law, human trafficking, and labor migration. She has a JD from Harvard Law School and a BA from Yale University. Professor Chong's articles have appeared in many academic journals, including the American Journal of International Law and many media outlets. She's been cited in the Washington Post, the Wall Street Journal, the New York Times, the Guardian, etc. Drawing on her expertise on human trafficking issues, Professor Chong has served as an advisor to the United Nations, the International Labour Organization, and the Organization of Security and Cooperation in Europe. Professor Chong has also served in leadership positions with the American Society of International Law and the International Law Association. She currently serves as a member of the Freedom Network USA and as a member of the Modern Day Slavery and Trafficking Working Group for the Gilder Lehrman, I think so, Center for the Study of Slavery Resistance and Abolition at Yale University. I think she will be focusing on questions regarding the International Organization for Migration, IOM, and its newly elevated role in global governance over migration, courtesy of the Migration Compact. She will also elaborate on the Compact's implications on anti-trafficking efforts. Second is Jill Goldenziel. Right? She is Associate Professor of International Law and International Relations at Marine Corps University Command Staff College. Dr. Goldenstein holds a PhD and an AM in government from Harvard University, a JD from the New York University School of Law, and an AB from Princeton University. Her scholarship focuses on international law, global governance, and feedback effects between international and domestic legal systems in the US and abroad. She's particularly interested in how the development of courts, constitutions, and regulatory regimes affect human rights. She's an expert in the law and politics of the Middle East, according to me. She's currently writing a book on international refugee law and US foreign policy. Dr. Goldenseal's work has been featured in the American Journal of Comparative Law, the Journal of Law and Politics, etc. She has also been a commentator on NPR and in other media. She is a member of the U.S. Speaker and Specialist Bureau of the U.S. Department of State. She was part of the preparatory process for the Global Compact for Migration, from the report leading up to the 2016 Summit for Refugees and Migrants, through the Intergovernmental Conference to adopt GCM in December, and now the implementation and follow-up through the IMRF. Her input today should be quite informative. Mr. Felipe González Morales is the United Nations Special Rapporteur on the Human Rights of Migrants. Professor Morales holds a doctorate and a master in advanced human rights from the University Carlos III and an LLM in international legal studies from the American University. He's a former president of the Inter-American Commission on Human Rights, where he was also a commissioner and the rapporteur on migrants and refugees between 2008 and 2015. He is a professor of international law at Diego Portales University in Santiago, Chile, where he is also the director of a master in international human rights law. He is an honorific professor at University Carlos III of Madrid, where he teaches international human rights law at a series of postgraduate programs since 2003, as well as in several other universities in Spain. He also teaches regularly at American University Human Rights Academy in Washington, D.C. His students are here to prove it. Professor Gonzalez was the founder and first director of the Center for Human Rights at Diego Portales University. I'll skip that. Professor Morales will focus on the practical advantages brought by the Global Compact on Migration, the first instrument with a wide support from states, leading to a multilateral approach to migration at the UN. Unlike the Convention on Migrant Workers, which has been ratified almost exclusively by countries of origins of migrants. As Professor Morales notes, the GCM is not, properly speaking, a human rights instrument. The challenge, therefore, for international bodies like the one he is in charge of is to develop an interpretation and implementation of the compact based on existing human rights standards. He'll tell us more today on that issue. So that's for the introduction. I have prepared just a few words to introduce what we're going to talk about. I promise I won't be long. This is not my doing. So we're going to talk today about the Global Compact on Migration. For those who are not familiar with the subject, here's a quick background. So remember, it all started with the adoption of the New York Declaration for Refugees and Migrants by UN member states, including the United States under the Obama administration in September 2016. Following that, two separate UN compacts were set in motion: the Global Compact for Safe, Orderly, and Regular Migration, that we're going to address today, and the Global Compact on Refugee. So the New York Declaration calls for, among other things, the prompt reception for all persons arriving in a country, whether refugees or migrants, reaffirms respect for the institution of asylum and the right to seek asylum, reaffirms also, in light with the principle of non-refoulement, that individuals are not to be returned at borders, provides legal stay to those seeking protection as refugees, reviews policies that criminalize cross-border movements, and pursues alternative to detention. The United Nations describes it as a landmark political declaration that is directed at improving the way in which the international community responds to large movements of refugees and migrants. It is meant to establish a global framework for a global response to a global phenomenon. That's the United Nations words. Based on this agreement, migration, like other areas on international relations, will be guided by a set of common principles and approaches. So, the goals of the Global Compact of Migration are similar to the New York, it's because it's based on them, and specifically include to establish official mechanisms to monitor human rights violations and abuse of migrants, review policies that criminalize cross-border movements, encourage family reunification, eliminate child immigration detention, focus on inclusion of migrants in host societies, provide safe passage to work, including legal avenues, and appropriate protections for migrant workers. So this compact was officially adopted last year, December of 2018, by the United Nations General Assembly in New York, 2 days after the adoption of the Global Compact on Refugees. This successful adoption of both concludes a 2-year process that began, like we said, in 2016. And it is a historic victory for the UN efforts to regulate migrant and refugee flows on a global level. Just a quick count, 41 out of the 193 UN member states chose not to endorse this migration compact, including the United States. By comparison, the Global Compact on Refugees got more support, perhaps, in my view, because of the humanitarian aspects of refugee crisis. So 12 out of the 193 UN member states chose not to endorse. To conclude, Chris Arbor, which is the UN Special Representative for International Migration, called the adoption of the Migration Compact a wonderful occasion, really a historic moment, and a really great achievement for multilateralism. She added, this would remain the the reference for all future initiatives dealing with cross-border human mobility. Something I don't want to say, but I want to stress the importance of the compact we're going to talk about. David is going to start.
Thank you. Thank you, Dr. Rush, for your introduction. Thank you to ISIL and the Human Rights Academy for having us, and thank you to all of us for coming. I need to start by telling you that my views tonight that I'm going to express are my own and do not represent those of the Marine Corps University, the Department of Defense, or any other part of the US government. And I'll go from there. Yes, that usually induces some giggles. So I've had the privilege of being involved in the Global Compact process nearly from the beginning, representing the Academic Council on the UN system, and at the very beginning of the process, representing the American Society of International Law as well. And so I've been attending the civil society stakeholders from before actually the UN Summit for Refugees and Migrants in 2016. And I'm still, I got to speak at the Intergovernmental Conference to adopt the Global Compact in Morocco in December, and then I'm still involved as part of the implementation and follow-up now, creating the modalities, which means the rules, the process for the International Migration Review Forum, which is the every 4 years meeting, or the meetings that are going to happen every 4 years to discuss follow-up and implementation for the Global Compact. So I'm going to focus my remarks today on all of that, how the Global Compact came to be, and then a little bit about what it is and what it isn't, which Dr. Rush started to get into, and I know that Felipe is going to talk about as well, and then what's next, and that will lead into Professor Chang's remarks as well. So, first of all, in short, the Global Compact for Safe, Orderly, and Regular Migration is to promote just that, safe, orderly, and regular migration, as opposed to unsafe, disorderly, and irregular migration, which is what we have seen in recent years. And that was literally the tagline used all the way through the process from 2016 until the present. So it's not to promote migration, to get more people to migrate, but it's to make the migration that's already happening and migration that's going to be happening in the future more safe, orderly, and more regular as well. And the goal of the process from the beginning was to be as inclusive and transparent as possible, and to have the Global Compact negotiated by states. So this is something that really differentiated it from the Global Compact for Refugees, which was a process that was led by the UN Refugee Agency, the United Nations High Commissioner for Refugees, or UNHCR. This was a process that was negotiated by states. The forum for it was the UN. The process was led by the representatives from Switzerland and Mexico, and the ambassadors to the UN from those countries. And it was led by states all along. But one thing they did that I thought was really remarkable was to involve civil society at every stage, at every aspect of the process. And civil society was involved to the point that there were informal stakeholders, civil society stakeholders meetings held at every negotiation, every one of the state negotiations. The representatives, the co-facilitators would have first thing in the morning on the second day of the negotiations, usually a meeting with the civil society stakeholders to say, hey, you're not negotiating this because you're not states, but how's it going? What do you think? What do you think is missing? And we would then have the chance to submit written comments and see what the conversations that happened in those meetings then reflected in questions that the co-facilitators would ask or input that would turn up in the next draft. And that was something that was really heartening to see, because as an academic, I know that the success of human rights initiatives, whether human rights law or any sort of global human rights initiative, really depends on civil society's involvement. Civil society's work in individual countries, whether they be democracies, civil society working through regular democratic processes, or in non-democracies, civil society pushing through whatever channels they can. That's the way that human rights agreements actually get implemented. So it was wonderful to see from the very beginning that recognized at the UN level and that recognized by states themselves. And I'll give one huge example of that, which was really a career highlight for me. In 2016, shortly after the New York Declaration on Refugees and Migrants was passed at the 2016 Summit for Refugees and Migrants that was held during UNGA Week, UN General Assembly Week, the UN needed to start working on the modalities, again, the UN speak for the process, the rules for how the Global Compact was going to come about. And so I was involved in a couple of the early meetings, and then in December, I get this email from the UN Non-Governmental Liaison Service on a Sunday that says, hey, can you show up on Tuesday, and there's going to be a civil society meeting, and if you're interested in speaking, let us know. And I said, okay, no idea what this meeting was about. So get on the train, still have no idea what this meeting was about. And it said, I get another email saying, all right, well, you're all going to have a speaking role. Okay. Get into the room, turn to the guy next to me. Do you have any idea what this is about? No. Okay. So nobody in the room has any idea what this is about. The non-governmental liaison people come in and they say, we're sorry, you had no idea what this is about, but we didn't even know that this meeting was going to happen. And it looks like it is. So basically, a bunch of states are really concerned about the role of civil society or civil society participating in this process, and they don't necessarily want civil society to participate in this process. So you need to convince them in your time, in your 3 allotted minutes each, that they should have civil society be involved in this process. And we're not sure if anybody is even going to show up, so figure out what you're going to say now. Okay, so we take our 10 minutes, figure out what we're going to say, and meanwhile, 50 member states file in, which was apparently an unusual, if not unprecedented number for that sort of meeting. And I guess it worked, because civil society was then very involved in the process from there on in. And it was a career highlight, certainly, to be one voice helping to make that happen. So what happened after that? So there was more preparation for approximately the first half of 2016, where the modalities were worked out. And then the UN engaged in first a consultations period, then a stock taking period, where they would figure out what was said in the consultations and then how to adapt that into the Global Compact itself. And then in 2018, we saw negotiations over the Global Compact, and then eventually the adoption of the Global Compact by states in December. A little bit more about how that worked. So the UN, the co-facilitators in particular, led a lot of consultations in 2016. By my count here, at least 23. And those took the form of thematic sessions, regional consultations held all over the world, consultations with civil society held all over the world, separate from the consultations that were held with states in various regions, and then multi-stakeholder hearings in New York and Geneva, which happened before, and during, and now after negotiations, and that involved all stakeholders. So states, civil society, private sector, all in the same room, talking about whatever hot topics needed to be addressed. The thematic sessions involved all stakeholders as well, and those included topics that were addressed in the Global Compact, including the human rights of all migrants, addressing discrimination, addressing the drivers and root causes of migration, addressing remittances, smuggling and trafficking, certainly big issues, which Janie will talk more about, and the one crucial issue, of course, irregular migration. So irregular migration and creating more regular pathways for migration and stemming irregular migration for states that were interested in doing that. So these were held all over the world. Just to give you an idea, the civil society consultations were held in Thailand, Lebanon, Mali, here in DC, Belgium, Ecuador, and Fiji. And those were done in conjunction with academic institutions and civil society organizations. And the regional consultations were similar in their geographic diversity as well. Then there was a stock-taking meeting in Puerto Vallarta at the end of 2017, and that led up to the negotiations in 2018. More stakeholders meetings occurred as the zero draft was prepared. And then in the first 6 months of 2018, there were negotiations every month from February until July, where states got into a room and really hotly debated the text and the commas and the periods and the quotation marks in the Global Compact. And this was really fascinating to me as an international law scholar for a lot of reasons, but one of them was that this looked really suspiciously like a treaty negotiation, despite the fact that the document didn't look like a treaty at all, and I'll get to that. But also that this was a non-binding document. This was never meant to be a binding document from the very beginning. And yet states were really interested in every little comma. And some of the negotiations got quite heated. The issue of regular versus irregular migrants and how to define them, and specifying that states still had sovereignty, had the discretion to distinguish between irregular and regular migrants, was a huge topic. There was no definition of migrant within the Global Compact, which in itself was a huge topic. This might have taken forever, which might have been one of the reasons why they left it out. But also, as a lawyer, and many of us in this room are or studying to be them, that causes some problems, or has the potential to cause some problems later on. Detention of children. The document stopped short of condemning child detention, which was a major issue in the negotiations. The issue of LGBT rights was also contentious. The document, the Global Compact text, says that it is gender responsive. Many countries wanted specifically the words women, men, boys, and girls included in the compact. And to many in the room, particularly from civil society, given that LGBT rights is a large reason why people leave their countries, this and LGBTQ individuals are not covered by the Refugee Convention, at least according to its interpretation in many states. This seemed like a big omission to many people. The Migrant Workers Convention was mentioned in the document, but not as much, did not receive as much weight as many states would have liked. I think Felipe is going to talk more about that. The prominence of climate change migration in the document was also less a hot topic than a serious issue that many states wanted included. One of the biggest points of contention in the negotiations was firewalls. Originally, the document talked about firewalls between public services that states had and law enforcement. So if a migrant were to access, say, the healthcare system of a particular state, the document initially provided that their information could not then be shared with law enforcement if they were regularly in the country, and that did not fly. That has been removed. So the access to and portability of earned benefits is also an issue. If you migrate to another country, can you take your welfare, your social security, whatever it is that you have in your home country or earn in your new country, can you carry that with you if you decide to leave or go back and forth? So all of this was negotiated. It was informally affirmed in July of 2018 to much cheering. And then some states began to withdraw from the compact, which was also curious, that states that affirmed it over the next 5 months or so began to withdraw from a non-binding document. We can talk more about that certainly in the Q&A. But eventually states did, for about 150 some states did formally adopt it at Marrakesh in December. And then a UN General Assembly resolution in support of the document was passed shortly after that in December as well. So the Global Compact doesn't look like a treaty. Talk a little bit about what it is and isn't. It doesn't really look like a treaty. What it has is 23 objectives, each of them with an actionable commitment, followed by a list of best practices. So to give a quick example, there's an actionable commitment, such as we commit to adapt options and pathways for regular migration in a manner that facilitates labor mobility and decent work, et cetera, et cetera. And then this actionable commitment is followed by the words, to realize this commitment, we will draw from the following actions. And then there's a list of best practices, such as promote effective skills matching in the national economy by involving local authorities and other relevant stakeholders, et cetera, et cetera. So some of these objectives are more concrete and others are more aspirational. Ensuring that all migrants have proof of legal identity and adequate documentation is pretty concrete. Eliminating all forms of discrimination, that's a little more aspirational. That being said, there is something to be said for having them all in one document. to show that these very concrete objectives should be achieved, not at all costs, but in conjunction with other human rights goals and other goals and programs that the UN is working on simultaneously, such as the Sustainable Development Goals. So that's what the Global Compact is in a nutshell. What isn't it? So first of all, it's not binding, as I mentioned. It's supposed to be a framework for safe, orderly, and regular migration, but not law. It's not meant to infringe on state sovereignty, which is very clear from the text of the document itself, which says just that, and also talks about state sovereignty in other places in the document. It's not to promote migration, and it's not just hortatory, as I mentioned. So it's not just rhetoric. There were articles that came out around the time that the Global Compact was passed saying, oh, this is dead on arrival. But states certainly aren't acting that way. States weren't acting that way during the negotiations, and states were not acting that way during the process during the actual adoption of the document in Morocco, nor at the General Assembly, because if you have a non-binding document, you don't usually, and you're a state, you don't usually object to that the way states did. And they did so both at the Intergovernmental Conference and also in the General Assembly by doing something along the lines of reservations and declarations, the way they would with a treaty process. So this is not your average non-binding compact. What exactly it is in international law, I'm still trying to figure that out. If you have ideas, I would love to know about them because I'm trying to write about it right now. But it's not nothing. States seem to think it's something far more than that. And another thing I'll say is it's not just a finish. It's not a finish to a process. It's the start of a new process because the implementation, follow-up, and review are going to be far more important for the significance of this document than the preparatory process itself. So what's happening with the follow-up, implementation, and review? The UN has created something called the UN Network on Migration, which basically consists of all of the agencies within the UN that deal with migration, which is a lot of them. And they're in charge of establishing a capacity building mechanism within the UN to help states and other stakeholders implement the Global Compact. The International Organization for Migration is the lead agency in the network and for the capacity building mechanism, and I'll let Professor Cheng talk more about that. The Secretary General is supposed to report to the General Assembly on a biennial basis about the progress of the Global Compact, and then an International Migration and Review Forum, the IMRF, will happen every 4 years, first time in 2022, which will be the main forum through which states can report on the progress of the Global Compact, and civil society organizations will participate in that as well. I'll close with a few quick thoughts because I'm sure I'm running out of time. So the effectiveness of the Global Compact, though, won't depend as much on any of these processes as it will on political will. So if states are going to implement the Global Compact, they need to be convinced that it's in their interest to do so. If individuals are going to push for the implementation of the Global Compact, or if voters are going to vote for the Global Compact to be implemented, or provisions or policies that are aligned with the Global Compact to be implemented, they also need to be convinced that it's in their interest to do so. So accurate data collection and evidence-based research is going to be particularly important. And the role of civil society organizations is going to be particularly important in, first of all, collecting this data, which is something that academics can do, and also that civil society organizations who work with migrants can do, and in also pushing states to then implement the Global Compact, and in influencing the dialogue that would allow that to happen. The dialogue is going to be a lot more successful if it's based on evidence and accurate data. It's the UN's job to start a process. It's the UN's job to lead the Global Compact process and to put issues out on the table. as they have with the Global Compact for Migration, as they have with international law in the past. But it's going to be civil society's job to get it done, to push the implementation and review process within their respective states. And to this audience, I want to say, if you do support the Global Compact for Migration or its objectives, everyone in this room has a role to play in the success or the failure of the document, and in promoting safe, orderly, and regular migration in the best interests of human rights and also international security.
Yeah. Felipe.
Thank you very much, Naila. Thank you. I thank the American Society of International Law and American University for this invitation. I think it's a very important topic that, as Jill was explaining, will be in the discussion of migration for a long time as a basis for the follow-up on this. Well, this panel has a very challenging title, which is the UN Global Compact on Migration, Strengthening or Diluting Well-Established Principles of International Human Rights Law. I don't know who was the person who invented this title, but it's a very challenging one. I'm not going to address the topic directly, but I hope that by the end of my presentation, I can give some lights about my thoughts about it. First, I think that my presentation will complement in several respects the one made by Jill. I participated since I became the Special Rapporteur on the Human Rights of Migrants in this process. That was in August 2017. So this was in the middle of the year of the contributions and consultations, and then in the negotiations process, and now in the follow-up. So I'm going to explain. It was a very participative process, and it's part really of a series of initiatives by the United Nations to address the issue of migration. Unlike the issue of refugees, for a long time the UN didn't have an agency as such dedicated to migration. The International Organization on Migration became a UN agency only in 2016, unlike the situation of the UN High Commissioner on Refugees, which is a very old institution almost from the very beginning of the UN. And I think this is not coincidence. It is the fact that there is only now the room for to start a multilateral approach of migration at the global level, because it has become really global, and many of the features that we can see here in the Americas, not only in the relationship between Mexicans and the US and Central America, but also in many South American countries, the same occurs in every continent in the world. And in fact, at this point, there is more south migration than south-north migration, as it was the typical feature. So at some point at the UN, a consensus was reached that some steps were needed. And in this regard, there was the adoption of the UN Declaration, the New York Declaration on Migrants and Refugees, the incorporation of the IOM to the UN, and then the processes of adopting a global compact on migration and another one on refugees. A separation that not everybody was, from the human rights perspective, was happy about. That separation of two compacts. But anyway, there was a change in that respect, and the fact that the Global Compact has been adopted, the Global Compact on Migration, means that the issue of migration is going to stay there, the UN, to be addressed in a multilateral way. From the point of view of the human rights of migrants, there are mechanisms that are prior to the adoption of the compact. But the treaty in this regard, the convention, the International Convention on the Protection of the Migrant Workers and their Families, was adopted long time ago in 1990. It took 13 years for the convention to came into force, and today there are 50, a little bit more than 50 countries which have ratified it. Almost all of them countries of origin. A few of them have become over time countries of destination, but that is an exception. And it's very clear that they are not going to occur that many more countries will ratify it in the next few years. So, in mentioning, just taking a brief look at the title of the of the presentation, well, I think it might be somehow theoretical to make a comparison between the Convention on Migrant Workers and the Global Compact. Well, the second is not a human rights instrument also, but in terms of standards, in the first case of the convention, we are talking about a treaty which don't have a wide ratification. Something different than the compact, which was widely adopted about 4/5 of the UN states. You can see this also. Jill was mentioning the strong participation of the civil society throughout the process of the adoption of the Global Compact. And when a person who is not familiar with the issue would say, why the civil society would need another instrument if we already have the Convention on Migrant Workers? Were they expecting that the standards would be strengthened? I would say, well, maybe in some respects. For instance, trying to get an outright prohibition of detention of migrant children, which was not achieved, but only working towards the end of detention of migrant children, or having some other aspects. But as a general matter, I don't think that was the expectation of the civil society. What the civil society saw was an opportunity to have the issue of migration addressed at the United Nations in many respects, not only by a committee who's the committee of coming from the treaty, which has jurisdiction over 1/4 of the countries only, countries of origin. So I think that was very practical from the point of view of the civil society. And I remember after the final text of the compact was adopted in New York in July last year, which was the same text for Marrakesh and for New York later in December, I would say that only a handful of civil society organizations were disappointed. Most of them were aware about the strengths and the flaws of the compact, but as a whole, they considered this a very important step. Very important step. So they didn't see it as a matter of comparing standards between the Convention on Migrant Workers and the compact, but rather that the compact would have in effect an impact and lasting effect much bigger than the convention. Now, in addition to the committee and the convention itself, there are several UN human rights special procedures which also address the issue of migration. The one I'm in charge of currently, which is directly connected human rights of migrants, but also one on displaced persons and one on trafficking, and so forth. And other mandates that also deal with the issue of migration in their own scope, like the Special Rapporteur on Racism, the working group on arbitrary detentions or forced disappearances, depending on the case or the situation. But many of those human rights mechanisms at the UN have been addressing the issue of migration over the last few years in their own mandates through reports and the like. And they participated, a number of them also, throughout the process of adoption of the Global Compact. most of these, or all of these, I think these mandates were created after the Convention on Migrant Workers was adopted. In fact, the Special Rapporteurship on Migration was established in 1999. That was 9 years after the adoption, although at a time when the convention was not still in effect. And these human rights mechanisms at the UN have universal jurisdiction. So in fact, it's not restricted only to those countries which have ratified the convention. And I think that these mechanisms have an impact. But I have to be honest, and I think that the impact is to some extent. And it really depends very much on who is in charge of the government of the country. And at some point, you can have a government in a country that is taking seriously the reports or communications from the special rapporteurs, but at other times that doesn't occur. So I think it is indispensable to have an instrument like this, an instrument that can be used and will be used and is being used by the special rapporteurs already, but at which the states will be directly involved. Because it's completely different to have a committee making the follow-up of our convention, which is important, or a special rapporteur preparing thematic reports on different matters, or sending communications to states. It's very different from having the states themselves directly involved in the follow-up process. Now, I don't see this as a dichotomy. I think it's very important that all these institutions, states, the UN as a whole, the UN human rights mechanisms, and the civil society, different ways participate in the follow-up of the global compact. But definitely, I think that the compact strengthens the approach towards migration in the UN, independently of the issue of the standards. I would say, as a practical matter, I think it really enhances the approach. The need for a multilateral approach at the UN became evident as more and more regional mechanisms were established at the regional level over the last few years, like the Colombo process in Asia, the Mercosur in South America, the Quito process on the Venezuelan migration, also in Latin America, the European Union, the ECOWAS mechanism in Western Africa, and so forth. So at some point, this multilateral approach at the UN was about to occur. So it really was a context that would produce this effect. Now, as the other point is the issue of the Global Compact on Migration not being a human rights instrument. It is not a human rights instrument. In the way it is built, it doesn't contain a catalog of rights and a set of limitations to some of those rights. But in a number of respects, the compact is connected and based on provisions contained in human rights treaties. The compact itself cites some of those treaties. So it's not something completely different from the existing international human rights law. Per se, it's not a human rights instrument, but it has a human rights component. Now, the challenge from the point of view of the human rights bodies of the UN and for a number of states who want to enhance the protection of migrants, the challenge is to develop an interpretation of the compact which is based on the international human rights instrument, and to incorporate also the gender perspective as part of the understanding of the compact. Both the gender perspective and the human rights are components of the compact, but the fact is that the compact really incorporates many components, like the component of security, especially repeated mentions to the issue of sovereignty and human rights. And you cannot find, like in a human rights treatise, like the right is established as a general rule and the limitation has to be looked at in a restricted manner. Here, you cannot be sure what weight more, whether security or human rights. So it's going to be a matter of interpretation and a matter of practice as well. So I think it's an issue that it's not settled really by the compact itself. On the issue of the non-legally binding character of the compact, well, this is expressly stated by the compact itself, but the UN human rights mechanisms have repeatedly stated, even throughout the process of preparation of the compact, that this would not mean that the obligations that states already have would evaporate. For instance, there are a number of obligations established in the case of the United States, for instance. The US has ratified the Convention on Racial Discrimination, the Convention Against Torture, the International Covenant on Political Rights. In case the US adopt the Global Compact at some point, which would need only the change of the executive government, unless this very same government changes its mind, but I mean, it doesn't require to go through Congress. In such case, the existing treaties would continue to be legally binding for the United States. Well, I explained this in my country, Chile, which was one of those that at the last minute withdrew from adopting the compact. Although until July in New York was fine with the compact and played a good role on that. I was saying it's not a matter of the compact establishing additional legal obligations related to the countries which have, for instance, ratified the Convention on Migrant Workers, like in the case of Chile. But it really means that there's going to be a multilateral approach. And another point, which I have not mentioned, it also means, in addition, something additional to the Convention on Migrant Workers, it means that it is a wide range of public policies that the states may choose to pursue to enhance the protection, to address migration and enhance the protection of the migrants. Of course, there is a risk on this last point. The wide range of public policies may significate that for some states, they may present, for instance, in the follow-up, this success while not addressing other areas. I think that is going to be a matter of how the follow-up is conducted. I don't expect that at the beginning, many countries will come up, be willing to show stuff or be scrutinized. But there are some which already started. Because the system of follow-up is completely different than the follow-up conducted by the human rights mechanism. In this case, it's still not clear, as Jill was explaining, how the General Assembly will operate in terms of conducting the follow-up, except for some general rules. But it's something that is going to be occur. That is going to occur. And this is another point that is important, that the whole process was extremely fast by in terms of the practice of international organizations, it took nothing. And now this resolution of modalities will be ready in the next few days, this month, which proves that something is going on there. I'm not saying that this is necessarily implied, this will necessarily imply a huge success in enhances the migration policies. But I think that this has been taken seriously by the UN to move forward in this regard. At the same time, the UN network on migration which is led by the IOM and which UNICEF, UN Women, the ILO, UNHCR, the High Commission on Human Rights also, and other agencies participate. They are going to conduct their own follow-up. And they held a consultation with the civil society to start this process in Geneva in April. And in addition to that, those special rapporteurs and other special procedures at the UN, whose mandates are connected to migration, we are also going to establish, since this will occur in a couple of weeks, a permanent exchange with the UN network of migration. We are not UN agencies as such, so we have to participate in a different manner. And finally, in this respect, the UN special rapporteurs and also the Committee on Migrant Workers have already started to make use of the Global Compact. So, for instance, when we have been sending communications to states which have adopted the compact, in addition to mentioning those treaties that the state has ratified, we are mentioning the Global Compact on Migration as well. And I'm not sure where this has already been done by the Committee on Migrant Workers, but when I attended online the last session of the committee, the members of the committee told me that they will do that as well. So they won't be able to establish the responsibility of a state based on the Global Compact because it's not per se a legally binding document. It's not a treaty, but they will use it also as a manner to, for instance, to interpret the Convention on Migrant Workers. I will try to finalize, not going to take too long. Okay, no. So, going to the title again. Yes. I don't think that the principle of international human rights laws, human rights law are diluted here. I think that the point is not making a comparison between the compact and the Convention on Migrant Workers, because those are instruments of a very different nature. And I expect that the compact will have a lasting effect. It is true, however, that, for instance, the jurisprudence developed by the special rapporteurs, by the Committee on Migrant Workers, by the Committee on the Rights of the Child, by the CEDAW on migrant women, and so forth, goes beyond the terms of the Global Compact on Migration. But I wouldn't say that the compact dilutes those standards, and I don't expect this human rights bias to retract from the jurisprudence that has been established. On the contrary, I think that the efforts of the human rights bias of the United Nations will be to look at the human rights at the Global Compact from the point of view of human rights, to provide a systematic approach about the issue of migration in cases.
Thank you. All yours.
All fine. How much
You have
time?
5 minutes. So
I'll try to. How are we on time?
if you can, 10 minutes.
Okay, I
if
will-
you
I
can
will
brief.
Speak quickly, given the time. So unlike my co-panelists, I was not involved in the Global Compact. I am an outside observer with lots of reactions and questions about the Global Compact. So as Nela said, I'm going to talk about the Global Compact from the perspective of somebody who's concerned about trafficking and labor exploitation and reacting to the Global Compact in terms of its implications for those phenomena. And I'll also speak about the International Organization of Migration and its role as coordinator. So in terms of the Global Compact and its significance, I think it's an important inflection point in the sense that we finally have a situation where there's now widespread recognition that we have to do something about economic migration or labor migration. It's been an area that states have been loath to touch and to really grapple with. So the fact that the Global Compact was developed is an important move in terms of recognizing that it is a problem that we can no longer ignore. So in terms of the contents of the Global Compact, when you think about it from the perspective of somebody who cares about trafficking, it's reassuring that there's a section on trafficking. Objective 10 deals specifically with trafficking. I will say that there's nothing new in Objective 10 in terms of states' commitments to deal with the phenomenon. And in fact, it reinforces the dominant paradigm of anti-trafficking law, which is very much prioritizing a criminal justice approach to it. There's some discussion, or there's mention of the importance of protecting victims of trafficking. Not a lot of elaboration on that point from a human rights perspective, but that's not surprising given the state of the anti-trafficking legal regime. What I want to focus on is Objective 6, which deals with ensuring decent work for all migrants, protecting migrants against exploitation. Also mentions improving recruitment mechanisms and admission systems to guarantee that they are fair and ethical. This is a critical component of the Global Compact for anybody who's concerned about exploitation, labor exploitation. Ideally, you would want a provision that has specific language that mentions, for instance, equal pay for equal work, a stronger commitment to safe working conditions, outright prohibition on recruitment fees being charged to migrant workers, prohibition and outright prohibition on the confiscation of identity documents and travel documents. Ideally, we would want a provision that eliminates visa, what we refer to as visa tying, which means that a visa is issued to a migrant worker, but it's only valid so long as the migrant worker works for a particular employer. We would want to eliminate the visa tying practice that is prevalent all over the world, and instead allow for portable visas or visas that enable migrant workers to be able to change their employers, particularly in the context where they are being exploited. But what we ended up with, and I think some of these provisions were actually in the zero draft of the GCM, but in the final draft, many of these commitments were substantially reduced. Visa tying provision was watered down, so now there's language about ensuring that migrants are able to have access to process. I forget the exact language, but it's a language that suggests that states should try to create systems where migrants are able to change their employers. But there's no strong, firm guarantee that the visa itself would avoid, that states would avoid conditioning visas on employment with a particular employer. So instead, we have sort of looser norms on that front in terms of allowing migrants to change employers. Rather than prohibiting all document confiscation, because this is a key tactic by traffickers to confiscate your documents so that you can't leave your employment. There's language about prohibiting non-consensual retention of documents, which is interesting language because, you know, if you think about the power dynamic between employer and worker, consensual retention of a document by employer, it's one can question what consent looks like in the context of a lot of these employer worker relationships. And critically, as Jill pointed out, firewalls. In the zero draft, there was mention of firewall between immigration enforcement and public services, and in this particular context, labor inspection, right? So the concern that we have is that when migrant workers are exploited, we would ideally have a situation where there would be processes through which migrant workers would be able to report the abuse. But what has always been a problem and led to vulnerability to trafficking is that the concern about reporting there's a concern that if you report abuse, that the employers will then inform immigration authorities about the the abuse, or inform immigration authorities about the worker complaining, and it could lead to a situation where, particularly when you're dealing with irregular migrants, where it can chill the desire, or it can limit and constrain the desire of workers to be able to report abuse. And so if they're concerned about the possibility of early termination of the guest worker programs in which they're participating because of the complaint, right? So some employers, if you complain, even if you're in a regular status on a formal guest worker program, if you complain, in most contexts, there's no anti-retaliation protections, right? So if you complain about an employer, that employer may then engage in early termination of your visa and early send you back home. And so without the sort of anti-retaliation protections, complaints are hard. It's hard to imagine workers feeling comfortable bringing complaints. And so it's really important to try to separate labor inspection, labor enforcement from the immigration processes, so that the labor rights can be more meaningfully upheld. So those are just a few thoughts about the substantive contents of the Global Compact as it pertains to one of the most important issues with respect to labor trafficking, which is the recruitment process. What I'd like to talk about and focus on more, however, is the role of the International Organization of Migration, which the UN Global Compact has elevated. The IOM, as it's known, is a rather understudied international organization. There's not a lot of if you were to try to research the IOM, there's very little scholarship on the IOM. And it's an organization that I think in 2016 became not a specialized agency of the UN. The agreement set up the IOM as a related organization, and that's significant because the agreement that brought IOM into the UN fold, sort of as a related organization, ensured that the IOM would maintain its independence as a non-normative organization. So what do I mean by non-normative? So when you think about UN specialized agencies, there is a sort of rights protective mandate. When you think about UNHCR, you think about OHCHR. The IOM doesn't have a mandate that is specific to rights protection of migrants, right? Its sort of catchphrase is ensuring that migration benefits all. So one of the concerns about bringing IOM into the role of coordinator, particularly given the potential of the GCM to articulate some rights relevant to migrant workers, is that if you have an organization that doesn't have a normative mandate that is specific to protection of migrants, the concern is that there won't be a secretariat that has a focus on advising states, providing guidance to states as to their implementation, that will be grounded in a rights framework. And IOM has, I said that it's an understudied organization, but what we do know about IOM and what's been documented is that leads us to the conclusion that IOM is a deeply ambivalent organization in terms of its goal, right? So its goal is to manage migration for the benefit of all, but it has an interesting structure that basically creates a situation where the organization engages in diverse activities that some would say are contradictory, if not controversial. So on the one hand, it claims a humanitarian mission. And I will say IOM has done a lot of terrific work around the world in some of its offices. It's an extremely decentralized organization. So it has a small headquarters in Geneva. while it's 10,000 or so employees, staff about 500 field offices and duty stations in 100 countries. So tiny headquarters, many, many different offices around the world. The structure of IOM is such that it's a project-based organization. So all of those different offices are responsible for raising money to sustain its own activities, right? There's no core funding that comes to it. So what scholars who have looked at IOM have found is that different offices will be engaging in projects that may work at cross purposes with each other. There's no unifying mandate that its goal is to protect migrants. In fact, in some of these contexts, scholars and civil society actors have been quite critical about IOM taking on projects that actually overlap with the agencies that do have migrant protective normative mandates like UNHCR, prompting human rights advocates to question whether or not states might strategically have brought in IOM to undertake activities in order to avoid the involvement of the more rigorous application of human rights standards by UN specialized agencies. So we've had this dynamic in the past where IOM has taken on some roles that UNHCR could take on, but states have opted to bring in IOM instead. And the concern is that is a move to dilute the application of human rights standards. Again, because of the non-normative mandate of IOM. When you look at its activities around the world, there is sort of a perception on the part of many civil society organizations that IOM is a bit of a hired gun. It's relied on by states for its jack of all trades, flexibility, its efficiency, and project delivery. There is this perception that IOM is, as one critical scholar framed it, an instrument of northern foreign policy, right? Because states, it has been an organization that has served states. And sometimes to the benefit of human rights of migrants, sometimes not so much. So on the one hand, it claims a humanitarian mission and has provided some wonderful humanitarian assistance in some contexts, but in other contexts, it has been involved in the ordering of movement in ways that have drawn criticism because of its use of coercive practices and activities, context particularly of immigrant detention. There has been criticism of its role in actually constraining rather than advancing the rights of migrants. And so one of the things to bear in mind as we think about implementation of the Global Compact is to pay close attention to the role of IOM as a non-normative mandate holding organization and what norms will guide its role in implementing or helping states to implement the Global Compact. I will say that in the context of labor recruitment, IOM has, and this is an example of the ambivalence that I mentioned before, IOM participated in at least 2 labor recruitment programs. They were pilot programs that IOM offices in Guatemala and Thailand undertook to essentially participate in labor recruitment directly. And they were working with, so there's 2 programs. One was to facilitate the bringing of Guatemalan agricultural workers to Quebec. And the other program involving Thai agricultural workers being brought to work in Israel. Both projects were quite controversial in terms of the rights of the workers who were brought, the Guatemalan workers in Quebec. There was, if you stand back and you look, and similarly for the Thai-Israel corridor and the program that was set up with IOM's involvement was the subject of a Human Rights Watch report because of the rampant human rights abuses that the Thai workers suffered. In both programs, had IOM had a normative mandate that would be rights protective of migrant workers, you would have the expectation that IOM might require better recruitment practices, have require all sorts of workers' rights protective norms in terms of pay and safety of workplaces, but their role was essentially instrumental in terms of facilitating bringing of these workers to these destination countries. There wasn't a discernible effort to try to lift the human rights standards in terms of workers' rights. And in fact, the two programs were ended up being highly controversial, particularly the Guatemala-Quebec program, where IOM was forced to end its involvement in this corridor in the wake of corruption scandal involving IOM Guatemala. And so there's some concern, and this could be the product of the projectization, decentralization function, right? If you have hundreds of offices that are tasked with raising money to sustain their activities, there's no. It's difficult to particularly when you have such a small central office to ensure that right standards are applied in all of the operations of its many offices, right? So the non-normativity is problematic in that context. But we are, I think, out of time, so I'm going to stop my
Just
comments
if you want to conclude quickly.
there,
Okay.
because it'd be good to be able to give
Okay.
people
Thank you so much.
a chance to.
So we'll take some questions. I think we can go beyond 7:30 because we were late starting. Just I want to ask one quick question, maybe Philippe or Jill. You're talking about the legally non-binding, and at the same time, I wonder, what does it mean if the United States did sign the New York Declaration, but then did not sign the compact? How does it affect any of its commitments? And second, how are the treaties that are in the Global Compact that you signed indirectly? Can they be used then to implement human rights from? What comes to my mind is an example in France of grandparents of ISIS children who are in Syria and want their grandkids repatriated, and they're suing French state because of a UN treaty they signed in defense, stuff like that. So
Well, the UN declaration is not a treaty either. So in that respect, I won't say it in terms of establishing responsibilities on specific violations by the United States, for instance. It doesn't add something to the existing treaties that the US has ratified. And when I was mentioning that we, the special rapporteurs, are now invoking the Global Compact in addition to the treaties that the respective state has ratified, we are not doing that because we consider that the Global Compact adds new obligations, because it's reflecting some existing obligations, in fact. But we're doing that as a way to emphasize that there is a human rights component in the compact. But I don't think that establish additional obligations. I mean, many of the obligations are based in these treaties that have a wide application.
okay, please. Is there a microphone somewhere? I think there was one, and there's one. Yeah, we can take one.
There was
Do you want to
one.
just take this?
Oh, we can,
and
yeah.
Yeah, we can share.
There was one, I saw it, it was laying here.
Hi, everyone. Thank you so much for your comments to start. They were very interesting. My name is Lillian. I'm a student at the Washington College of Law for the summer program. I have a question that is mainly directed towards Jill, but of course, if anyone else has a comment. I'm quite interested in the issue of climate migration, and I'm wondering if you could say a little bit more about some of the tension that arose in the negotiations surrounding that issue. And following on from that, whether you see the compact being able to lend anything to the kind of climate displacement issue and, you know, the creation of a mechanism to deal with that particular issue.
What do you prefer? You prefer to wait or just?
Given the time, maybe it's best to take a few and
Okay.
then turn to us. Oh,
My name is Roxana. I'm a lawyer from the Russian embassy. And my question is the following. In the national statement of the United States on the adoption of Global Compact on Migration, one of the reasons of non-participation of this instrument is indicated that this instrument could be a base for formation of customary international law, so-called soft law. Do you think that this instrument really could be a base for the building of the norms, of the customary norms of international law, even with non-participation of the United States in this document? Thank you.
Hi, my name is Alejandra. I'm a student at the Advanced Studies program in the American University. And I have two questions. I know that it was a little bit heated, the debate also on migrants fleeing violence, for example, and the discussion between considering them refugees or migrants, and where would that issue be placed on consultations and negotiations. So I just wanted to know on what was the final result on that, because in Latin America, for example, we have a broad definition at the Cartagena Declaration that is different from the Geneva Convention. And also if the Global Compact would elevate the political cost of not complying with international human rights standards or obligations that are included in other treaties from now on. I don't know if it would be possible to.
Thank you for being here. My name is Luke. I'm a law student at George Washington. I had a question regarding the breadth and comprehensive nature of the compact, specifically regarding displaced persons. In international legal scholarship, we've seen a lot of issues with where scholars are torn between whether or not they have to dilute the 51 standards that are set for refugees, or whether they should adopt new standards to deal with displaced persons. Do you feel like the compact takes a stab at that and tries to answer the question of like what protections are afforded to displaced persons, or are there a lot of ways to go until we find that out? Or are we still in the same phase where we're attempting to apply the protections that refugees get to displaced persons? Thank you.
That's it? Okay. Jill, you want to start?
sure. So I'll take the ones that are most relevant to my work, and then you can all read.
Yeah.
You can all read more. So
The first one was directed to you.
yeah. So does the global? I'll take the displaced persons issue, which also relates to migrants fleeing violence. So as I mentioned, the Global Compact doesn't define migrant, and the Global Compact for Refugees does not define the term refugee either. Both of them refer to the 1951 Convention related to the status of refugees. Global Compact for Migration specifically says we keep these as distinct documents and recognize the previous legal frameworks. So the answer, I think, to both of those questions is no. I don't think the document does really anything to clarify the distinction between refugees and migrants, other than that a lot of human rights advocates were not happy that refugees and migrants were two separate processes, recognizing that many of these people are invulnerable. Many refugees or migrants, regardless of what you're calling them and what the reasons why they fled, are in vulnerable circumstances, and all of them have the same human rights guaranteed by international human rights law. And that is something that is specifically said in the Global Compact, that refugees and migrants all are entitled to the same human rights protections. But in terms of actual definitions, no. The documents do nothing to, frankly, to clarify those. And that was certainly of frustration to me, but I realized pretty early on that I lost before I walked in the room on that one. So, and in terms of the issue of customary international law, so first of all, I'll say the document does not look like a treaty. So the idea that the document itself could become law anytime soon, that's not going to happen. This is not the type of instrument that states could immediately adopt into their legislation through ratification or in the US or by any other process. Could the document itself be norm creating, and could those norms then become state practice, which could involve into customary international law? Eventually, yes. If all states decide to, say, adopt identification documents for all migrants, that could be something that if enough states are practicing it and following it, that could become considered a norm or an obligation to make sure every person really has identification papers. Would that affect the U.S.'s sovereignty or the sovereignty of any state that is a persistent objector? No, because that's how international law works. If you're a persistent objector, even to customary international law, I'm simplifying a lot of international law here, but if you're a persistent objector, no, it's not going to bind you. So therefore, it wouldn't affect state sovereignty in that way. But one of the functions of international human rights law is naming and shaming, right? That's a core part of international human rights work. And the more states that are following a particular practice, the worse you look if you're a state and that you don't. So that's what I'll say for now. That's a process, naming and shaming, and starting to look like a state that's not following the rules in the international community. That can happen much more quickly than a practice evolving into or than states following a particular practice and evolving into a norm that could eventually become law.
Want to add something, Felipe?
No, I would like
Janie?
a comment on her presentation.
Oh, please go ahead.
About the IOM's role. Now, because I fully agree with you that there have been quite a number of controversies about over time about the role of the IOM, and we, the special rapporteurs, because we're not UN agencies, we can publicly criticize the IOM, and we have done so. I did that in my visit to Niger last year because of the work of the IOM with the European Union there. But for the countries, for the states, from the very beginning, you could see that the IOM, in the 90% of cases, the IOM was the favorite agency to lead the follow-up. But I think that in conducting the follow-up, the IOM and all the other entities, the UN agencies that are part of the UN network on migration now, they are going to be scrutinized very close. It's very different from having this operation in the Sahara Desert, like that, having this in the General Assembly in New York or in Geneva, where there are many civil society organizations. So I don't expect that the IOM will run by itself. And in fact, what we as special rapporteurs are pursuing is to establish a relationship not only with the executive secretariat, which is in charge of IOM, but with all the agencies working together. And that's the meeting we are going to have. I know it's not an assurance that everything will go smooth, but that was what I want to say. And I fully agree with the need for having the human rights component into the IOM mandate.
There's a question about the displaced that was not addressed. Anybody? Look.
I thought I covered that.
Yeah, I thought she covered it with the definition of migrants. Was that part of?
No.
The one I didn't, I know I didn't get to was the
Yeah.
climate migration. And just to clarify, I don't think it was so much that, I don't think there was really tension over it in the negotiations, not from what I saw, and I didn't attend all of them, but it was more that a lot of states were trying to bring it and succeeded, I think, in bringing it to the fore. And we started to see a lot of states banding together in the negotiations and making joint statements. And we heard a number of states banding together to give comments about climate change migration and elevating the importance of climate change migration in the convention itself. It was not necessarily all the states that you would think. Like it was not all of Latin America banding together to, or all of the Pacific Island nations talking about any particular issue. There were global, cross-regional coalitions that formed, which was something that was interesting and very nice to see. So I think that states did succeed in giving climate migration a prominent place in the document and raising awareness of it, certainly throughout the negotiations, and that it gives states and migrants and civil society organizations, anyone affected by climate change migration, another tool in their toolkit to use and say to states, look, this is an important issue and we have committed to doing something about it under the Global Compact, so let's push forward.
Okay, well, I think we're done. Thank you so much, Janie, Jill, and Felipe. I learned a lot. I hope you did too. And I think, like Jill said, it's just the beginning. The process has just started, and migration is an amazing subject, and we'll be talking more. Thank you for coming, and reception.